of time at that point, it would be the way I was raised back in the 90s. You show it for, you either say I show it or I'm showing it for inspection. And then you lay the predicate.
Then you approach, you lay, and then when you move it in, I say, is there any objection?
If that's how the court prefers, I have no problem with
Yeah,
that.
all right. Thank you. All right, so anything else?
I don't know if the issue, we need to argue
The fabric?
fabric.
I didn't get any case law.
I don't think we need to do that right now because we don't intend on doing that today. Is that correct? Are we doing the fabric today?
Judge, the court asked for me to have that witness present over lunch so that the testimony could be proffered outside the presence of the jury.
I take it back to
I believe I did. I have a meeting at 12, so we may have to do it at the back end of the lunch.
Okay, I told him 12. He works nights, so he took
was
off
this?
early. Sergeant Greg Thomas. He works nights on patrol, so he took off early to work last night to make sure he was...
Yeah, and that's not your fault. I know I said that, and then I was told afterwards that I have this meeting that unfortunately I have to attend. I don't know how long it's going to be, but maybe if I attend 15 minutes of it, we could do it that way. And maybe if he's early, I could break for lunch. How long do you anticipate the proffer is going to take?
I'd probably have about 20 minutes of questions, 10 to 20 minutes of questions on my side.
And
That's my guy. I'm crossing.
is that am I supposed to, because you're saying that, know that it's going to be a very long time on cross? I mean, we're talking about the specific...
It all depends upon what he says, but it could be.
The specific issue of the fabric. Well, I also asked for any case law from either side, and thus far I haven't received anything.
Judge, if you'd like, I can give you a copy of his deposition, which is absolutely crystal clear that he says he doesn't know what that is, has no idea what it is. It could be a textile, it could be anything. So I don't know what process.
So does the state believe he's going to
his transcript?
Does the state believe he's going to testify to anything different than what he said in his deposition?
I wouldn't say different, but I would say more robust, where he's going to say, I don't know what this is.
Okay,
I can't say that it's a T-shirt or it's a, what the exact item would be, but he can say it is a T-shirt-like material. It is a cotton-like material. He's got the ability to say that. Whether he can say this is a Fruit of the Loom T-shirt, no, he's never going to be able to say that.
So if this was a missing body and there was a cylindrical object, someone being able to testify it's bone-like would be the past the gatekeeper function of having someone testify and then allow the state to argue that it's a bone without an expert coming in and saying that the cylindrical object was in fact a bone?
Well, I think there's a difference in that, Your Honor, because when we're talking about bones, that's not something somebody sees, handles, deals with on a daily basis for their entirety of their life. I mean, to not be flippant, those are inside of the body, and so that's not something that's readily apparent to the everyday person, where I would argue that a T-shirt or a T-shirt-like material, a cotton material, is vastly different. That is something that for someone's essentially entire life, they are going to come in contact with those types of fabrics. And so can he lay that foundation of, yes, this is a cotton-like material, a T-shirt-like material? Sure, I think that's different than, I would agree with the court, you're going to need expert testimony to say that this is a bone, because that's not something that people are dealing with in their everyday life.
Why do we have textile experts if the nature of fabric is within lay witness opinion? It's not. It's just not.
Well, and I think a textile expert's going to be...
Why didn't you send it to FDLE to be analyzed?
That's not a decision that's mine to make, Your Honor. That was a decision made by
But if
my
it was
office.
yours, would you have?
I'm not going to speculate on how I would have handled my case.
I'm not letting him testify as to his opinion of whether it's a T-shirt or not. Just not doing it. That is the subject of expert testimony. That is why we have rules that require expert disclosure. That's an opinion that it's not relevant without the opinion that it is a T-shirt, and he can't offer that because he's not qualified. So that's my ruling. I'm sorry.
Is the court willing to allow him to offer testimony that is a fabric-like material?
But what's the no? There's no relevance. If you don't go that next step, there's no relevance, because then the jury is just left to speculate without someone offering the opinion of what it ultimately is. And I'm not saying that this could not have come in with a textile expert to say that it is consistent with and offer within a reasonable degree of scientific certainty this came from a t-shirt, then absolutely, by all means, the jury gets to hear it. Or if it was identifiable, if it was clearly a t-shirt but was burned to the point that there was only, the neckline and the sleeves. But what I'm hearing is it's simply a small piece that you can't tell. And that was his testimony and deposition, that he can't tell. But fabric-like material still leaves us in the realm of speculation as to what it was. There's a lot of things that are made of fabric-like material other than T-shirts. So without some form of opinion that it was in fact a T-shirt, it's just not relevant.
If the court's not going to allow that testimony, then I don't believe that there would be a benefit to proffering him, because it does not sound like there's going to be admissible testimony under the court's ruling.
I agree. I don't think there's any need to proffer. I mean, without an opinion, and it's not the subject of lay witness opinion, so without an opinion that is, and I think the proper person is someone with textile textile expertise to have analyzed it, but we're not there. You don't have that. And it's not your fault. I'm not suggesting it's your fault. The state should have submitted it to somebody who can come in and give us a lot of scientific information about the swab and then offer an expert opinion that it's from a T-shirt.
Understood.
All right. All right, you're welcome. Anything else? State ready with the witness?
To answer your question, nothing else. I'll refer to your other questions about that.
All right. Is the jury all here?
Yes, they are.
Sergeant. It came up regarding jurors in the elevator and jurors sometimes being for, even if it's just for a moment, in the lobby, and the possibility of seeing or hearing or interacting. Is it possible, the suggestion was made from the attorneys and the state concurred on it, came from the defense, but the state agreed, that in an abundance of caution, if they could be staged somewhere else, perhaps the first floor, and then brought up in the elevator, because something happened this morning with a juror in the elevator and some of the defense attorneys, so that they would be under the supervision of a bailiff while they're being transported up to our floor. They can still be, I suspect, put in courtroom 52, so that we're not putting them in the jury room until they're all ready. But the issue was if they could be staged on another floor, and the Deputy Estea said that may require another deputy, so I asked him to consult with you.
It definitely will require another deputy. I'm not sure that would solve the problem with interacting with the public. However, whatever the court decides to do, we can try to make that happen. Unfortunately, staffing is an issue with that.
Well, I don't know. State, what do you say? Staffing is an issue.
Judge, I'm sorry, I missed that last part.
With the jurors being staged somewhere else, it's a staffing issue for the sheriff's office.
Well, Judge, obviously, I don't want to cause a staffing issue for the sheriff's office.
Nor do I.
Do share the concerns about this continual elevator, and I know it's completely inadvertent. I'm not suggesting that it wasn't, but that is concerning.
It's concerning, well, but if they don't have the staff to do it, I can't force them to.
Judge, may I offer a suggestion?
Sure.
If the jurors today are taken down to that area of the first floor, say, hey, this is where you all are going to meet. Okay, this is away from the public. It's kind of a tucked little corner there. They can go, if they come in through the main entrance, they can come across the tunnel, they can go down the stairs. They don't even have to go in on the elevator. They can go down the stairs and they're right there.
You can't tell them not to use the elevator.
I realize that, but if they can do that, that's an option. And then one of the deputies can just go and pick that group up once they're all there.
All right, let me see.
Bring them up.
Sergeant, do you have any suggestions that would be within the staffing?
Actually, it would probably be better if they just mustered inside of the jury auditorium. We'll make contact with the staff.
So they're not even walking across the sky bridge. I don't think, well, I don't know where the attorneys come in from, but I suspect that it could be a problem that you're walking across the sky bridge with them.
there's not going to be any kind of way where we can stop them from inadvertently interacting with anybody.
Coming in the front door.
However, we can meet them in the jury auditorium where I don't have to put a staff member down there.
Excellent.
And once they're all there, I'll make contact with the jury services and we'll just go pick them up.
Excellent. So then they'll be under the supervision of a deputy, walked across the sky bridge, put in the elevator, and brought up to our floor. It sounds like.
Yes.
Is that acceptable to the state?
Yes, Judge, and I believe all of the attorneys come in through the criminal courthouse door.
Okay.
So we're not using the Sky Bridge.
Okay. All right. And not even going into that building, because that's now where they're going to be staged in the other building.
Yes.
My concern was that there was no guarantee if we did it on the first floor that there wouldn't be an attorney who was getting in the elevator as they were getting on there. But it sounds like what the sergeant has suggested is an excellent solution to all of our issues. Does the defense have any problem with that?
We agree with it. Great suggestion.
State agree?
Yes, Judge.
I agree. Great suggestion, Sergeant.
No worries. We'll take care of it.
All right, appreciate it. All right, so I think we're at the stage where we bring in the jury and we call your first witness. Well, not first witness. Did we go through 4 yesterday? Did I miss one? We did 5. Sorry, your 6th witness. But I'll just say your next witness. Let's get the jury. Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, good morning. Welcome back. Happy Tuesday. I know we're starting a few minutes late. I take full responsibility for any delays in scheduling, but we are about ready to get going. I simply need to ask you the question that I always ask when I haven't seen you and you come back into the courtroom, and that is, by show of hands, was anybody exposed to anything about this case, or has anybody discussed anything about this case between the time you left yesterday and the time you returned into the courtroom this morning? By show of hands. Thank you. Let the record reflect there are no hands. And again, welcome. We are going to now turn to the state and ask them to please call their next witness.
Luciano Alonzo.
Luciano Alonza. Mr. Alonzo, good morning and welcome. If you'll come forward to be sworn as a witness, wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you, sir. Do you swear or affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. If you'll follow the bailiff now to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat in that chair. Make yourself comfortable. The microphone in front of you is adjustable. Perfect. You may proceed.
Thank you. Would you please state your name and spell your last name?
Luciano Alonso, Alonzo.
Mr. Alonso, I want to take you back to 2010. Did you work at a restaurant called Anna's?
Yes, I did.
Who owns the restaurant?
My girlfriend.
She's still your girlfriend?
Yeah.
You still helping out around the restaurant?
Weekends.
Okay, not quite as much as you were back in 2010.
Yeah.
In 2010, were you at the restaurant most days?
Well, yeah, most.
Did you become familiar with the regular customers who would come into the restaurant?
I know a lot of customers.
Okay.
A lot of Waimama, Ruskin, Sun City.
Okay. Where's the restaurant located?
Waimama.
Did you meet Michael Keetley through Anna's restaurant?
Yes, I did.
Back when do you think you first kind of met him?
Years. I think maybe in 2022, maybe. No, I mean 02.
Okay, 2002.
Yeah.
So let's talk specifically about 2010. Would you have considered Mr. Keetley to be a regular customer at the restaurant?
Yes.
How often would he come in, specifically in 2010?
Not recalling too much, but I think maybe once a week he would come by, or at least twice a month.
Okay, so say 2 to 4 times a month?
Mm.
Would you talk with him when
I had, I wasn't busy. Sometimes I would sit and we would talk.
Did you learn that the defendant had been shot in early 2010?
Oh yes.
How'd you learn that?
Well, I heard it, from the news. I heard it from him. I heard it from people.
Okay.
I shot in Old Sun City.
All right, let me stop you for a second. Specifically, what did the defendant tell you about being shot?
Well, he said he was selling ice cream in Sun City.
Objection. Lockett Foundation, may we approach the bench?
Sure.
All right, Mr. Luciano, so we were talking about your conversations with the defendant at Anna's. Would you agree with me that we're essentially going to be talking about more than one conversation as we move forward?
Oh, yes.
Okay, so let's start towards the beginning of 2010. Did you speak with the defendant about the defendant being shot?
Yes.
Did you learn information from the defendant on what happened?
Yes.
So tell me what does it tell you?
He told me he was selling ice cream in Ocean City, and he said a car, I think he said, blinked his lights to stop, and he stopped, and a girl approached the van and asked for ice cream or soda or something, and when next thing he turned, it was a guy with a gun pointing at him, had it on his face. So he said he had a gun in his van, so he went out to reach for the gun, and when he went like this, the guy had his gun already on him, and he just shot him. He said that guy didn't even blink, he just shot me. You know,
Okay.
He put his hand and he shot him in his hand, and that's how he got his hand disabled.
These are all things that the defendants told you
Yeah.
at the restaurant.
No, well, we talked. I mean, I think it was in the restaurant. Well, we used to talk a lot, but I don't know. Maybe at the restaurant. Pretty much sure it was.
Were there other times outside of the restaurant that you actually met
I used
up
to go
with
to his
Mr.
house
Keetley?
sometimes.
Wait, hold on. I apologize, sir. You got to wait till she finishes because the court orders take down. She can't take both of you down.
I'll finish my question and then I'll give you a chance to answer it. Were there times outside of the restaurant that you actually met with Mr. Keetley and you bought a mower and a golf cart from him?
Right.
2 separate occasions?
Yep.
Were you at the home of Mr. Keetley on Bonita Drive to buy that mower and that golf cart?
Yes.
Okay, so now let's go back to some of the conversations that you had in the restaurant with the defendant. We had this initial conversation. Were there follow-up conversations when he'd be in the restaurant with you?
I don't really recall, but I think we had conversations, but I don't know if it relates to the same, what you're asking,
Okay, I'll ask it more specifically. Was the name Creeper ever brought up to you?
Yes,
Who brought that up?
he did.
You kind of made a motion. Tell me who brought that up to you.
Michael.
Where did he bring that up to you?
The restaurant, I believe.
Do you remember what year that was?
No, it was after he got shot.
Okay. How long after he got shot? Approximately.
Maybe months, 6 months, 8 months, maybe a year.
Still in that 2010 time frame?
Objection, leading, rephrase.
No,
Well, hold on. Let me ask you a different question. When the name Creeper was brought up to you, was that after the defendant was shot?
yes.
Was the name Creeper brought up by the defendant to you more than once?
Yes.
Do you remember how many times?
A few, maybe. It was brought up a lot.
Did the defendant ever ask questions of you regarding, did you know who Creeper was?
Yes.
So tell me about that.
He would ask if I knew who Creeper was, if I could find out where a Creeper lived or where he hanged out or who he really was. I didn't know who Creeper was.
All right, you answered my next question. Did you know who Creeper was?
Nope.
Did you ever learn who Creeper
No.
was? Did you ever tell the defendant anything that you knew about Creeper?
No.
During your time in the restaurant with the defendant, did you ever notice any physical limitations he may have because starting in the beginning of 2010, so after he was shot?
The beginning he used to come in the cane. He couldn't use his right arm. He always, couldn't. He had to use his left hand. I think he was right-handed.
Okay,
Yeah.
let me stop you for a second. Did you see him with the cane further on into 2010?
I don't recall how. I know he wore the cane, but I don't recall when.
Was there a time he stopped using the cane?
I think further along the way he stopped using the cane, but he still had I think he still have difficulties walking or I don't know if he ever got shot, and I know he got shot in the hand, but I don't know why he was using a cane. I don't recall
Okay.
where. I think he got shot in the leg too. I don't recall.
Are those things that were told to you by the defendant?
No, I knew he got shot, but I don't remember where he got shot. I don't recall that.
Sure. So let's go back to what you're able to see, not maybe what somebody's told you. Did you see him using a cane and him being the defendant in the beginning of 2010?
Yes.
Towards the end of 2010, did you see him using that cane still?
I don't recall.
All right. Did you see any changes in his physical abilities, specifically with his hand, as we went from early in 2010 to later in 2010?
More movement to his hand.
Okay. All right. Did you ever talk to Mr. Keetley about how these physical limitations had affected his life?
No. He pretty much told me how it affected his life.
Okay. Did you all talk about how Mr. Keetley felt about the people or the person who did this to him?
He was upset.
All right. Did he say anything to you about what he wanted to do to those people?
He was kind of mentioned he was upset, and he wanted revenge.
Were you ever asked about the address Ocean Mist Drive?
By who?
Will you tell me? Did the defendant ask you about that address?
Yes.
Tell me about that conversation.
One time he asked me if I knew where Ocean Mist was, and I said, no, I don't know where Ocean Mist.
Where did that conversation take place?
I think it was the restaurant, or might have been in his house. I don't recall that specifically.
remember?
Yeah, specifically where he asked me, but he asked me where. I think it was at the restaurant.
Okay. Do you see the defendant in the courtroom today?
Yes, right there.
And is that the person who came into Anna's restaurant?
Yes,
Is that the person who you bought the lawnmower and the golf cart from?
yes.
Can you tell me what he's wearing?
Beige jacket.
Your Honor, please let the record reflect that the witness has identified the defendant.
Right, just so reflect.
May I have a moment?
Yes. Good morning, sir.
Morning.
How are you?
Fine, thank you.
So, I have a few questions for you. I heard you being asked about dates. Can we agree that you do not have specific dates when these interactions occurred?
No, not specific dates, or like I don't have a diary where I write them.
That's okay. Here's why I asked that. The prosecutor kept saying in early 2010. Do you know when Michael Keetley was shot?
Nope.
Do you know what year he was shot?
Nope.
Do you know how long he was in the hospital?
Nope.
I believe when you've spoken in the past, you have spoken to a detective, Lugo. Is that correct?
Mhm.
And he recorded a statement with you.
Right.
You remember that?
Mhm.
That's a yes, right?
Yes.
Sorry, we have to keep the yeses and nos for the record. When he took the statement from you, do you recall that he first said, "We have talked about this before"? Let me phrase that better. Bad question. Before he recorded you on tape, he had a conversation with you off tape, right?
Mm-hmm.
Right?
Right.
Okay. And so when you gave a recorded statement, that was actually the second statement that you gave, right?
Right.
Would you agree with me
I
on that?
agree.
And would you agree that's the first statement that was recorded?
The first statement was recorded.
Right. Second statement, only one of them was recorded. Can we agree on that?
Yes.
All right. Let me ask you, as it relates to you're hearing that Michael Keetley was shot, right? That was a big deal, right?
Right.
Lots of people were talking about it, right?
Right.
People not related to Michael Keetley were talking about it, right?
Right.
They would come in the restaurant, right? Because this was a big deal. Yes?
Yes.
Okay. So when you had people talking to you, strike that, let me reload it and ask a better question. When Michael Keetley first came in after he was shot, can you give me a month?
No.
Okay. So can I understand?
Can I give you
that-
a year?
Cannot give me a year? All right. I think I heard you say at some point in time, the way the question was asked, how much time had passed between your finding out about the shooting and him coming in, and you went as far as a year after that, right?
It might have been, well, it was a while.
It was a while. And I understand that this is 2010, and I understand that you don't keep a diary,
Mhm.
right? I got all that.
Yeah.
We're talking about something 13 years ago, right?
Right.
The number of conversations you had with Michael Keetley were a lot, right?
Right.
And not all of them were about him getting shot.
No, there was always there was some about business, trying to make a business. He wanted to do a Cuban sandwich business. He wanted to make an ice cream drive-through at my restaurant. And there was a lot of conversation we had.
I'm glad you brought that up because he actually wanted you to talk to Anna, who owns the restaurant, to see if we can put the ice cream
Yeah.
in the shop
Yeah,
itself.
we wanted to do a little partial ice cream business in there.
Yeah, because it'd be better for them to drive to him than him to drive to them. That
Yeah.
was the conversation, right?
Right.
Anna didn't go for that.
No. It's too small of a business.
I understand. But I say that because you knew he was driving an ice cream truck.
Right.
And you knew he was going throughout Old Sun City Center and Ruskin and Waimea, right?
Right.
But I'm going to come back a little bit more. We can agree that the first time you saw him after he was shot, you noticed there were significant injuries to him, right?
Oh, yes, sir.
All right. There was talk about his moving of his hand, right?
Right.
That you recall the movement on his hand got better.
Yes.
But you recall how his hand
Yeah.
does this.
Mhm.
And when I say this, sorry, I've got to do it for the record, almost like his fingers are bent down and his thumb was there, right?
Right.
And you would recall that he could not use this hand to eat, right?
Right.
And that he was right-handed.
Right.
And that he had to do not only left hand, but he had to do one hand, right?
Right.
You even helped him with his food a couple of times, didn't you?
Well, just
Right.
take the plate to him, or but not feed him.
Well, I understand that, but maybe help him cut his food so he could use his left hand, right?
Well, I don't really recall, but
Do you recall that if he used his right hand, he'd have to use his left hand to undo his fingers, right?
I know that I recall. If I can recall, he didn't use his right hand for a while.
Right.
You know.
And then when he started to use his right hand, he would have to physically manipulate it with his left hand. You remember that, don't you?
Don't really recall.
What you primarily recall is that he was one-handed.
Yeah.
All that he did
Mm.
throughout that time after he was shot, right? Let's talk about the limp. He had a pronounced limp. Do you know what I mean by that? That
Yeah.
when he walked, you could tell he was limping, right?
Right.
And it was consistent, right?
I believe when he first got his injuries, he was consistent. He had a cane. He was consistent. But like I say, after time, I don't recall. If he was consistent.
Right. And I want to be clear on that. When we say that there was a cane and the prosecutor suggested that there was a time there was not a cane, that's not your testimony. It's that you don't remember if he was using a cane, right?
I don't remember if he was using a cane.
Right. And so he very well could have been using a cane that whole time. You just do not know. Can we?
I got used to seeing him, I guess, and
Sure. All right. So when we're talking about Michael Keetley and his injury, it was something that was noticeable, right?
Right.
I think you said he came into your restaurant pretty regularly.
At the beginning, when he got injured, he kind of, I guess, pretty much had too much time on his hand. It would come more frequently, you know.
There was a time where he did not come at all.
Yeah.
And that, as far as you know, was a gap between maybe when he was shot, when he was in the hospital, when he was recovering, those types of things, right?
Right.
You were asked questions about whether Michael Keetley talked with you about physical limitations, right?
Right.
Recall that question? You were also asked, well, let me see if I can put it right. There were a large number of conversations between you and Michael, right?
Right.
You would see him, you would come talk to him. He's a friend,
Mm-hmm. Right.
and he, you don't remember when that first conversation was
About what?
about his injuries.
I mean, when he first came, that he was injured. You know, we kind of came to the conversation of his injury.
Sure. What I'm saying is you're not sure when that was.
Oh no.
And how much time between a first conversation involving his injuries and a second conversation, right?
Right.
Or a third conversation.
We just talked, and like I say, any day could be a different conversation.
Correct. And within that whole context of conversations, he described to you the difficulties he was having in
Oh,
his
yes,
life,
sir.
right? You were asked a question about revenge, and within these conversations, he told you he could not use his right hand, didn't
Right.
he? And that is consistent with what you saw, yes?
Yeah.
And he told you that he couldn't always wipe himself.
Yeah. Right. That's why one of his upsets was that I couldn't even, do that. He was like, that was his upset. You know.
His mom had to help take care of him, right?
I'm pretty sure his mom took care of him. I don't know. That's something
Okay. He had different emotions with you. You know what I mean by that? Well, let me see if I can ask a question. This day that you say he wanted to have revenge, right?
Okay.
You remember that was the day he was telling you he was in pain and he was not feeling well,
Mm-hmm.
right? That's what you remember about that day.
Well, yeah, I think that he was not having a good day, maybe.
Yeah. And you thought he was tired. And you thought he was not feeling well, right?
I mean, I don't recall.
Well, you certainly know him to be friendly enough where he's talking to you that he cannot clean himself after he uses the bathroom all the time, right? And so he's expressing to you emotion or frustration, right? Or anger, right?
Right.
And that's not every conversation, is it?
Oh, I mean, I think if you're referring to that conversation, like, that he say he wanted revenge, or maybe he was he was mad, he was upset, maybe he was not having a good day, but but he had that, how you say, two emotion, like one day he would be nice guy, we're talking, have a great conversation, the next day he'd be all frustrated, and like you say,
Just an expression
yeah,
of emotion.
expression. Maybe like if you take it to saying like he wanted revenge because what happened to him. I mean, I guess maybe having a bad day.
Sure. You said he mentioned the name Creeper,
Right.
and he asked you about Creeper, right? Were you aware? Well, first of all, I think I asked you, but let me make sure. You knew he drove a ice cream truck,
Right.
all throughout Ruskin, Waimama, right?
Sun City.
Sun City as well,
Old
right?
Sun City.
Right. You said there was one day he asked about Ocean Mist Court, right? But you knew that was on his right. He said,
Yes,
okay.
yeah.
Yes, sir. Thank you. Judge was telling me before this time. I just asked you a question and you said,
Yes.
meaning yes. Can we
Yes.
agree with that?
Yes.
All right. When you know the streets in that area, Domino, Ocean Mist, Are you familiar with any of those streets?
I knew Domino, but I never knew Ocean Mist. I never knew where Ocean Mist was.
Did you know what Michael Keetley's regular route was?
No.
Okay. Can you agree with me that Ruskin, Waimama, that area is pretty close to Manatee County?
Right.
Right? And so whether he was going into Manatee and Hillsborough, right?
Right. Well, if I recall, he mentioned one time he got robbed in Manatee County selling ice cream too. But I recall he saying one time being robbed in Manatee before he got shot.
Maybe one more reason to build the ice cream on Anna's restaurant, right?
I guess.
So let me tell you, when he asked about Creeper, he didn't say he wanted to kill Creeper. He didn't say he wanted to have revenge. He was asking, do you know about Creeper?
No, I believe I recall he mentioned that out in the street, the word was that Creeper had shot him.
As far as the name Juan Gatron, did he ever mention that name to you?
No.
I'm going to ask you a few more names. And the question on each of these is, did Michael Keetley ever mention? Did Michael Keetley ever mention Sergio Gatron?
No.
Did Michael Keetley ever mention Richard Cantu?
No.
Jose Rodriguez?
No.
Ramon Galan?
No.
Daniel Beltran?
No.
Gonzalo Guevara?
No.
Ever hear the name Gonzo?
No.
Ever hear the name Magic or Spider?
No.
Jay?
No.
As far as the time frame, when Michael Keetley was talking to you, he consistently told you he wanted the person or persons responsible to be caught, right?
Right.
He wanted them to be arrested, right?
Right.
And he told you he had been calling the police, right?
Right.
And giving them the information.
I believe, yes.
Yeah. And so I want to be very clear here. When he told you what happened to him, did he say it was someone described as black?
No.
Okay. That there was a black female who flagged him down and two people in ski masks who came in the truck?
No, I don't recall what he mentioned as who shot him.
He just told you, as far as it related to this, that the word on the street was that it was Creeper as one of the people.
Yeah, one of you.
Did you have in your business a tip jar or donation jar like other businesses did for Michael Keetley?
I believe, yes.
Okay, and it had his picture on it, right?
I believe.
Okay, and you see Michael Keetley here
Right.
today,
Mhm.
right?
Right.
Maybe a little older. Let me ask you this: at that time in 2010, whenever it was, would you describe him as out of shape, fat, overweight?
No, pretty much the same as he looks right now.
Okay. So skinny or
Yeah, skinny.
regular build?
Yeah, bird of build, yeah.
Okay. Would you describe him as a very tall person?
Yep.
Okay.
So,
How tall are you?
6.
Yeah, 6 feet. All right. Is he less than you?
I believe we're pretty much the same height.
Okay. But this is his build back in 2010. Yes.
Yes.
Just can we approach real quick?
Yeah.
Yes. Ladies and gentlemen of the jury, just go ahead and stand up and stretch your legs for just a moment. Just briefly stretch your legs. All right. Excellent. Go ahead and have a seat. And we'll pick up where we left off. Mr. Grant, you may proceed. Ready? Yes.
Nothing further.
Yes, sir. May I proceed?
Yes.
Mr. Alonso, we can agree that you don't remember specific dates, fair?
Right.
Object leading.
No, it's overruled.
The events that we've been talking about, the conversations you had with Mr. Keetley regarding his injuries, was that before or after he was shot?
After.
Any conversation that you had with Mr. Keetley regarding his injuries after he's shot?
After.
Can't say what year it may have been, right?
No.
Object,
Okay.
asked and answered, and leading.
That was rephrased.
When the defendant was in your restaurant, you didn't cut his food for him, did you?
Object leading.
Sustained.
Did you cut his food?
I don't recall.
Was there ever a time that you cut the defendant's food when he was in your restaurant?
Objection, asked and answered.
Overruled.
Do you have a specific memory of the defendant's inability to pick up a drinking glass in your restaurant?
No.
Do you have specific memories of the defendant using a cane?
I don't get the question. What?
Did he walk with a cane?
Yes.
Right? Did you give an interview to Detective Lugo early on in this investigation?
Did I give a...
Did Detective Lugo interview you?
When he first approached me, he came with questions.
Okay.
And then
Go ahead.
that's where he said he was going to record after he questioned me. You know, he questioned me first.
Was that interview recorded then? The
Yes,
second time?
that second time was...
Have you had an opportunity to review that interview?
Nope.
Would that transcript of that interview refresh your recollection on whether or not you saw the defendant walking with a limp or a cane?
I guess he would.
Okay. For the record, page 6 of 10. May I approach the witness?
You may.
Just take a look at that for me, if you will. Look up at me once your recollection's been refreshed. Do you want me to ask you the question again?
Hmm?
Do you recall the defendant walking with a limp after he was shot?
Objection, improper memory refreshment. May we approach the bench?
You can approach.
Mr. Alonso, has your recollection been refreshed?
Yes. Can I ask, is that The statement or the recording?
Well, do you want to take a look at it again?
No, I'm saying, is it the statement Mr. Lugo took, or is it the recording he took?
Let me approach with this again. You can take a look at it, and then you tell me.
Objection, he's asking whether it's the non-recorded statement or the recorded statement he's looking at.
Well, if you all stipulate as to what it is, I think he can be told. Are we all on the same page as to what it is?
Judge, can we approach again?
Yes, let them bring the transcript. We're going to take a morning break. Please not discuss the case amongst yourselves or with anyone else. Please not do any research related to the case. All rise for the jury. Jury has exited. Everyone may be seated. Mr. Alonzo, you may step down. You are still in the stand, so please do not discuss your testimony with anyone. We are going to take a 10-minute break. I would like the rules of professional responsibility copy and the oath of admission to the Florida Bar during the break. Thank you very much. Witness in. Let me just start off by saying that if there's any debate about whether there are rules of professional conduct and responsibility to apply to all of us in this courtroom, I'm happy to send the jury home for the rest of the day and we can go through all of them, including the administrative order, which adopts all of them in this circuit. I hope that that's not necessary, but if that is necessary, I'm happy to do it. What brings us to this situation is the argument that ensued about the refreshing of recollection, which is something that is essentially taught in the first year of law school, and debating over the semantics of it, and then sniping at each other and talking over each other, which is just going to end. It's not going to happen anymore, okay? Because if it continues, I'll simply declare a mistrial. That's what I'm going to do. That's my warning that we all need to be professional. We all need to be careful, okay? It came up that perhaps the jury can hear what I'm saying from over here because I talk loud sometimes. I'm not yelling, but I do talk loud. And I don't know that that white noise is sufficient. In fact, I'm told that if defense counsel can hear it, that perhaps the jury can hear the discussions at the bench. So there's a fix for that too. We can send the jury out every time there's a need to approach, and we'll eliminate any possibility of the jury overhearing what we're discussing at the bench. What also adds to the problem is the number of people that approach the bench, who some may be talking to me, some may be talking to each other, some may be talking to other people, and it creates a problem. So, also pursuant to the administrative order, I have the ability to impose additional rules in the courtroom that may address responsibility and professionalism of attorneys. And so I am going to announce a rule that we are going to follow from this point forward. Only one representative from each side will be permitted to approach the bench. If that person requests an opportunity to go back to the table to discuss with someone else, I will allow it. But we're only going to have one person at the bench at a time from this point forward. Now, we're going to go back to the witness that was on the stand and the refreshing of recollection, and I am going to allow the state to identify whatever the object is. That was his question. That's what brought us to this. He asked, when the state asked whether his recollection was refreshed, whether that was a transcript of the recording. And I'm going to ask you all first to tell me if you agree that it is or it is not. That's something very simple that the attorneys outside the presence of the jury can make a determination on. It either is or it isn't. So I'll start with Ms. Hodges. Ms. Hodges, is what you were using to refresh the witness's recollection a recording or a transcript of his recorded interview?
It is, Judge. At the top, it's titled Transcribed Interview with the date of October 8, 2012. The location, interview of, and then who conducted the interview. And then it has line by line the interview.
And I understand that, but despite that, there's some confusion because there was two interviews that appear to have been made simultaneously, and it's created some confusion. The defense brought that out on cross. I think the witness was confused as well, whether that's something that the detective wrote up after he talked to him and then recorded him. It appears, and you all may know better than me and correct me if I'm wrong, that the detective talked to him, asked him some questions, and then said, okay, I'm going to interview you. I'm going to record you, and then re-interviewed him and recorded him. Basically the same, I don't know, I wasn't there, but essentially about the same incident, and now it was being recorded. So now there's this air of confusion as to whether that is in fact the statement that was made while being recorded, or it's the statement he made right before he was recorded and was somehow written down or somehow recreated by the detective. It sounds like, and I'll give the defense an opportunity to agree or disagree, because I'm sure you got a copy of the recording, an audio of the recording, and then can look at the transcript and agree or disagree as to whether that item that they've used is in fact a transcript of the recording. So I'll turn to the defense. What's your position? Is that the transcript?
It is what they purport to be a transcript. It's not certified, so I'm not wiggling here, but it is the transcript that came with the audio.
Okay, did you listen to the audio?
Yes.
Do you have any reason to believe that what's on the transcript is different than what's on the audio?
I'm not going to say with 100% accuracy. Obviously, as the court knows, these are not certified transcripts, but I don't know of any substantive...
Because certainly
Correct.
in your preparation of this case,
Right.
if you had looked at the transcript and listened to the audio,
Yes.
we'd hear about it, wouldn't we?
Correct.
Absolutely.
If there was something that was in there purported to have been said or not said, and it was substantively different, absolutely.
All right.
So I think the court's clear on what I'm saying. I'm not saying it's 100% accurate.
I understand.
Right.
So that is why when we bring the witness in, I am going to allow Ms. Hodges to identify that as a transcript of the recorded part of the interview. And then ask him again, because he hasn't answered yet, technically, whether his memory was refreshed, because he responded with a question. Is that the transcript of the recording? Right. So we're going to go right back to that spot. He's going to be told that, yes, it is, and then he's going to be asked if his memory is refreshed. If he answers his memory is refreshed, then I will allow the state to ask the question again, which is something about a cane, whether he saw him using a cane. And then we're gonna move on. Okay, I am not going to allow a re-cross-examination of the item that was used to refresh recollection. I've never seen that. I've never had anybody request that, and I'm not going to allow it today.
Gotcha. Can I put argument on the record?
You can.
Yes.
You may.
All right. So when a witness testifies at a trial, I'm citing to Earhart.
Not so fast. You're reading, and the court reporter can't take down when you read fast.
Yes, sorry, I'm trying to be better with our time. Thank you. When a witness testifies at a trial that a certain fact or event occurs, it is improper to show that witness a writing under the guise of refreshing recollection because the testimony of the witness is based on a present memory. Here's the problem with that. When he is given a transcript, okay, that he does not know, all right? I'm not taking an issue with what it is, but he does not know what it is of himself. He's just being told what it is, right? And so now he's going to look at something, and the question is going to be whether in fact he has a present memory or whether he's just going to regurgitate something ascribed to him in a transcript that he's never seen, that he's never compared. So he may feel like, I just have to say, yes, my memory is refreshed. Whatever is in that transcript is okay. The memory of a witness does not need to be refreshed in that situation.
Well, but there's no question that his answer on cross-examination by you was, I don't remember. You made it a point. It's not that you're not saying it didn't happen. You're saying you simply don't remember, which is what opens the door wide to refreshing a witness's recollection. But now if we're going to dive into whether or not when a witness says my memory has been refreshed, they're actually being truthful on that or not, that's... that's why I'm requiring the question, which I agreed with your objection, and Ms. Hodges said, well, I asked him to look up when it was refreshed. No, I'm not going to accept that. I want him asked a direct question, did that transcript or did that item that you read refresh your recollection? And if he answers yes, it did, I'm going to allow them to ask the question again. I have no idea what his answer is going to be. We haven't gotten that far. But I think it satisfies the procedure. And I'm going to allow that, and then we'll see where it goes. But if we continue to debate first-year law school things like refreshing recollection, I don't know where this trial is going to go and when and how it's going to end. And if they have the opportunity to do this again, then who knows? They might have fabric experts testify the next time. So I'm just simply saying, let's try to get through this trial. And let's be professional about it, please.
I understand where you're going. I need to finish putting the law on the record.
Go ahead.
Because I think the court is saying this, but I want to be clear. If a witness's memory is jogged and the testimony is based on an independent recollection, it is immaterial what is used. That was what we said at the bench, that anything can be used to refresh recollection.
Exactly. That's the rule.
Right. But usually we have an ability to challenge that, right? And I understand you're not giving me recross on that point to ask him whether in fact that is actually your present memory or whether you're just repeating what you see on a piece of paper. In the end, I agree with you, Judge. We're belaboring a point because here's the deal. The witness has testified on direct examination that he used a cane. He couldn't remember. And I cross-examined and elaborated on that point. He used a cane. Now apparently they're refreshing or impeaching as to whether he had a limp or not. So
exactly my point.
Gotcha.
I don't know. I'm not going to comment on the evidence or but do we really need to get into this over something like this? And I'm not in any way suggesting the defense should not do their job and do it to the best of their abilities. But let's get through this refreshing and let's move on. It's going to be 11 o'clock when we get in and get going, and my plan is to go until I've got a meeting at 12, so I've got a break at 12. So we'll get an hour and we'll break for lunch.
Sorry, I didn't mean to cut you off. We have a hard stop at noon.
Noon, yeah.
Okay.
Yeah.
Okay.
Are you going to do it on Zoom?
In fact, I have a professionalism committee meeting at noon.
Do you want me to have your Zoom open ready?
Mhm.
Are you going over it?
No, please, if you'll open it, and then we'll go right up to noon.
Absolutely.
Yeah. All right. So let's bring in the witness, Mr. Alonzo. And again, thank you all for your patience with me and your professionalism. I appreciate it. And hope that I am as professional as you are. I strive to be. We are getting Mr. Alonso. Mr. Alonso, welcome back, sir. We're going to put you back on the witness stand, and then we're going to bring in the jury. You can line them up. I will, as always, accept all responsibility for any delays with the jury and tell them not to hold that against anyone, except me, if they did. They need to.
Is there anything else we want to deal with the juror situation at this point? Whether we address it?
Before they bring him, do you want me to hold him back when we break for lunch to question him, or do you want to hold off on that? I've been watching him.
Yeah. What I would suggest, I know we've got a hard stop. Maybe we can address whether we talked to him before.
Let's talk. We can always bring him in before. I'll give him till 1:15 if we break at 12, and we can always bring him in early. But I suggest everyone keep an eye on him. I've notified the bailiff, so everyone's watching him, and I will address it if I see him by, again, having them stand up and stretch their legs, but ultimately we'll have to talk to him. I agree.
Okay, that works. One more in the back.
Okay, so we're waiting for them. They're not waiting for us, for the record.
All right, judges are all ready. All rise, jury entering courtroom.
Jury is present and seated. Everyone else may be seated at this time. Ladies and gentlemen of the jury, welcome back. Did you enjoy your break? Was it sufficient time? I take full responsibility for any delays. I know that have been longer than any of other breaks. I take full responsibility. Please do not hold that against the parties, the attorneys, or anyone else. Let me also, just in abundance of caution, ask, as I always do when you leave the courtroom, did anybody talk about the case, or was anybody exposed to any reports about the case outside of the courtroom? By show of hands. Let the record reflect there are no hands. Again, thank you all very much. We're going to pick up where we left off with the witness. Ms. Hodges, you may proceed.
Thank you, Your Honor. Mr. Alonso, I'm going to approach and show you a transcribed interview on October 8th of 2012 between you and Detective Lugo. Do you remember Detective Lugo recording an interview or questioning with you?
Well, he first started questioning me, then he started recording me. That's why I'm saying that script is that when he questioned me or when he recorded me?
When he recorded you.
Okay, that's all.
Do you remember that?
Yes.
Okay. May I approach the witness? Now, I'm showing you, I'll show you the top page of that. Do you see your name on the top of that page?
Yes.
And do you see Detective Lugo's name
Yes.
on the top of that page? Do you see the date, October 8th of 2012?
Yes.
All right. Now I'll turn your attention to page 6 towards the bottom of that recorded interview. And when you've refreshed your recollection, look back up at me, please. Has your recollection been refreshed? Answer out loud for me.
Yes.
Do you recall talking to Detective Lugo about the defendant's walk?
Yes.
Do you recall talking to Detective Lugo about whether the defendant used a cane?
Yes.
Did the defendant walk with a limp when you saw him in 2010?
I don't recall.
All right. Does reviewing your recorded interview from October of 2012 refresh your recollection, remind you of what you had said back in 2012?
Objection.
Yeah, I'm going to sustain. Approach. Thank you. Appreciate that.
Mr. Alonso, do you recall an interview? So we've had this original conversation and then the part where you were recorded with Detective Lugo.
Right.
Do you recall that?
Yes.
Do you recall being put under oath, swearing to tell the truth
Yes.
when you were interviewed in the recorded part by Detective Lugo?
Right.
Do you remember making the statement, I never saw him like with a cane or limping. Walked normal, but he showed no strength on one side, especially when he got shot, especially in his arm. Do you remember making that statement?
Well, I can only say what I said in my statement was 2012, right?
It was 2012.
Well, I guess I have a better recollection of what I said there to what you're asking me now. Like,
Understood. Thank you. In that same interview, so that same recorded interview that we've been talking about, do you recall making the statement that the defendant tells you Creeper is responsible for shooting him?
Object.
Legal base.
Object beyond the scope.
Anything else?
Improper refreshment of recollection. Asked and answered.
Overruled. I'll allow him to answer the question.
Do you need me to repeat my question?
please.
In your interview, so we're only talking about the portion of the time you spent with Detective Lugo where he was recording what you were saying. Do you remember saying Creeper was responsible for shooting him, meaning the defendant?
Yes, he told me that Creeper was the one he felt that had shot him. That's what the word was in the street, that he got shot by Creeper.
And this is told to you by the defendant.
Yes.
Object, leading, asked and answered. Overruled.
Do you remember in that same interview the defendant telling you he was doing his own investigation?
Yes.
Object, beyond the scope, may we approach?
No, it's overruled. Move on.
Do you remember the defendant telling you and you telling Detective Lugo in your interview the defendant wanted revenge?
Yes.
Object, asked and answered.
I don't remember it, so I will overrule it.
Do you remember in that same interview the defendant saying to you he wanted to find Creeper?
Yes.
He wanted revenge. Do you
Yes.
remember those words being used by you?
Yes.
Objection.
That's asked and answered. That's sustained. Can't keep asking the same thing over and over again.
Yes, Your Honor.
Sustained. Let's move on.
Do you remember in that same interview telling Detective Lugo the defendant saying he wanted to kill him?
Objection, may we approach the bench?
Yes.
Yes, can I see the exhibit? It's not just the exhibit.
It's on the exhibit.
What you showed him?
Yes.
All right, sir, you were given a copy of a transcript,
Yes.
right? It's something you've never seen before, right?
No.
Okay. Something you had not looked at before you testified here today, right?
No.
There were two statements. One with Detective Lugo without reporting, right?
Right.
That statement that you were looking at, that particular statement, you have never been given a copy of. Any summary, any report, or anything to look at. Is that correct?
No, I don't think I have.
Right. As far as you know.
I don't know. They gave me some transcripts, but I didn't look it because I pretty much.
Sorry.
You don't cut him off.
I did. I thought he was done. Sorry, I did cut
No.
you off. Go ahead.
No,
finish.
so I pretty much knew what I had testified or what I had said on my statement.
Right. So there was the first question and answer with Detective Lugo, and then there was a second reported statement, right?
Because Detective Lugo approached me with a question,
Right.
and then he made me into a witness. When he started questioning me and he started asking questions, that's where he got interested and say, like, can I record you? And I said,
Sure.
why?
Oh.
I said, I mean, I know what I know. He said, I said, I'll say what I have to say, but I do not want to get subpoena. And he said, there's over 100 persons in this case, and you probably won't. So I said, okay, I'll say what I have to say. But see, that's what I was, like, when he approached me was with a question, why had I called Mike? That's what the question came to me.
Right. And as far as the timing, as far as all that you saw and experienced with Michael Keetley, you do not have a full memory of that. Is that right?
It's been like, how many
12 years.
12 years. Yeah, I mean, I can relate to the script that she's making me recollect. That's what I said. It might make me recall what I said. But what I'm saying is, it's been 12 years. So you want me to say word to word what I said? I mean, I can't.
We just want you to tell the truth. And have you done
Yeah,
that
that's what I'm
today?
saying. That's what I'm trying to say. The truth was,
And you remember the injuries as you described?
yeah, yes, sir.
Nothing further.
Anything from the state?
No redirect, Your Honor.
May this witness be released by the
It's
state?
released.
And by the defense, released or subject to recall?
Subject to recall, please.
All right, sir, you may step down. You don't have to wait outside, but you are subject to recall. If we call and let you know that we need to bring you back over the next couple of weeks.
All right.
Thank you. And I'll ask the state to please call your next witness.
Deputy Christopher Sullivan.
Deputy Sullivan.
Approach it very briefly.
Yes.
Deputy Sullivan.
Yes. Deputy Sullivan, good morning and welcome. You'll come forward to be sworn as a witness. Wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Bless you, bless you, bless you. Go ahead, have a seat. Make yourself comfortable. The microphone in front of you is fully adjustable.
May I proceed?
You may. I'm sorry.
Will you state your name and spell your last name?
Christopher Sullivan, Sullivan.
Where do you work?
Hillsborough County Sheriff's Office.
And what's your current title and role?
Title is Deputy Christopher Sullivan. Role is I'm currently assigned to the Port Security Section, and I'm also a member of the Underwater Recovery Team.
Not your role back in 2010.
No,
What was your role back then?
I was a patrol deputy in District 4.
Now let's talk kind of broadly first. As a patrol deputy, are you assigned a district and a zone?
Yes,
Is a zone within a district?
yes,
Kind of a smaller area within an area that's a portion of Hillsborough County?
yes,
Okay. As a patrol deputy, do you respond to calls for service within your zone?
yes,
Do you respond to calls for service within your district?
yes,
Are there times when you actually may be required or asked to respond to a call outside of your zone but still within your district?
yes,
Do some of those calls come out that typically are going to be more either complex cases or just more going on?
yes,
Okay. Let's talk about November of 2010, working as a deputy in which district?
in District 4.
Southern part of the county?
Yes,
On November 25th of 2010, were you working?
yes, I was.
What was your schedule back then?
I was a evening shift is what they called it. It was 1500 to 03 in the morning.
Would have started on the 24th and gone into the 25th?
Yes,
All right. Do you get called out to 604 Ocean Mist Drive?
yes, I did.
What time do you arrive on scene?
It was 02:34 in the morning.
Are you the first unit there?
No, I was not.
Do other patrol units, marked cars, full uniform, do they beat you there essentially?
Yes,
When you arrive, are medical professionals already on scene?
yes, they were.
Fire rescue.
Yes.
How many, if you recall, medical professional, ambulances, things like that, do we have on scene at this point?
I don't recall how many were there.
More than one?
Yes.
All right. Is your responsibility when you arrive on scene different than potentially the first deputy who's going to get there?
Yes, it would have been.
Tell me how.
The first deputy there would have accepted, if there were victims lying on the floor, he would have been taking care of the victims or assisting Hillsborough County Fire Rescue in that. Obviously, if he's already dealing with that, then the perimeter would have started being established.
All right, so what is a perimeter? Let's start there.
The crime scene perimeters, we're going to take the crime scene tape and establish a large area around the crime scene to keep people out other than law enforcement.
Now, in this circumstance, were there people who were actually in the home, in the residence, that were not involved or unharmed from the front porch?
I don't recall if there were other individuals within the crime scene or not that
By
were
the-
there already.
Sorry, go ahead. I interrupted you.
That were there already, but prior to the crime scene being established.
By the time that you're putting up a perimeter, is anyone who would have been inside that home or on that front porch that is still living removed from that perimeter?
They would have been removed, yes.
Is there an interior and an exterior perimeter?
I don't recall in that scene if there was. I was on the exterior, so I don't know if there was an interior one.
All right, so when we're talking about an interior and an exterior perimeter, what are we talking about here?
The exterior perimeter would have been the crime scene tape where you keep everybody out, and then the interior would obviously have been smaller within that area, in the initial area.
Are crime scene logs kept of who's entering and exiting a crime scene and the times?
Yes.
What's the purpose of that?
To document who entered the scene.
Preserve evidence?
Yes.
Okay. So as you arrive on scene, medical professionals are still there?
Yes.
Do they eventually leave?
Eventually, yes.
Does your role as a, we'll call it first on scene deputy, start to change at that point?
I was already on perimeter at that time, so my position didn't change when they left.
All right. Fair to say that you're not the only one there.
Correct.
Have other patrol units responded to Ocean Mist at this point?
Yes.
Have detectives and supervisors been notified of what may be going on?
Yes.
Are patrol units briefing each other on what may be happening that they're handling?
Yes.
When you've set up a perimeter, what is the purpose of keeping people out of that interior area?
You want to keep the integrity of the crime scene, maintain it.
What does that mean?
Unauthorized personnel can contaminate the crime scene, so you want to keep anybody who's not inside there already authorized. You don't want them to contaminate the scene.
While you're on scene on the perimeter, do you become aware that an individual named Daniel Beltran had left that scene but then had been brought back?
No.
Does that become information known to you through other deputies?
No, I don't recall that at all.
All right. When you're establishing that perimeter and staying in one spot, do you have other people doing essentially the same thing in other locations on that perimeter?
Yes.
What's the purpose of that?
It was a large scene. You had to have multiple deputies on the scene to make sure nobody broke the crime scene.
While you're present, and I don't want you to tell me what anybody says, did you speak to individuals who had been either in that home or around that home?
Not in the home. They would have been outside of the home at the time.
Did you learn information from them? Don't tell me what they said.
Information, yes.
Was that information then provided to either a supervisor or a detective?
Yes.
Did you speak with the mother of Juan and Sergio Guitron?
Yes, I did.
Don't tell me what she said, but did you speak to her on scene?
Yes.
Did you become aware of an individual who had called 911?
Yes.
Don't tell me what they said, but did you speak to that individual and gather information?
Briefly.
Did you relay all of that information to supervisors and detectives?
Yes.
May I have a moment, Your Honor?
Yeah.
Yes, Your Honor. Deputy Sullivan, I believe you said that you were not the first responding deputy on scene that evening. Is that correct?
That is correct.
So by the time you arrived, it was the first set of deputies that immediately arrived,
Correct.
had already been there.
Yes.
Potentially other deputies as well.
Yes.
Medical,
Yes.
the victims that were there, in and out,
Correct.
as well as potentially people that were within the home coming out,
Yes.
neighbors and other people that weren't necessarily involved but heard the commotion and came out.
Prior to the crime scene being set up, that's possible, yes.
And because you came and became involved after all of these events occurred, correct?
Correct.
And is it fair to say that this was a chaotic scene?
Initially, that's fair to say.
Obviously, it was a call for multiple victim shooting,
Correct.
and a lot of people arrived on scene, both deputies and people, either witnesses, involved victims, correct?
Correct.
So you have no control of what you're doing when you're setting up a perimeter as far as all of those events that happened before your arrival, correct?
Correct.
So it's fair to say that as things occur after a crime or an incident occurs, you have no way of preserving it in that moment until you arrive.
That's fair to say, yes.
Okay, you may have a moment.
Redirect?
No redirect.
Release?
Excused.
Excused, and excused by the defense or subject to recall?
Excuse.
All right, thank you, Deputy. Make that down, baby. Excuse the witness at this time. Ladies and gentlemen, jury, we're going to go up till 12. I have a hard stop at 12 because I have a meeting. So I'm going to ask the state to call your next witness, and we'll see whether we have to break in between that witness or not.
We more than likely will. It's
All right.
Crime Scene Technician Committee Patel.
Excellent. Crime scene technician Patel. We can, what I'll tell you, if you have a good breaking point, maybe 5 to 8 minutes before noon, that'll be a good time to stop.
Yes, sir.
And welcome. If you'll come forward to be sworn, wherever you're comfortable, if you'll face me and raise your right hand, please. Thank you. Do you swear affirmative testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, ma'am. If you'll follow the bailiff to the ramp that leads up to the witness chair, please watch your step. Go ahead, have a seat in that chair, make yourself comfortable. That microphone in front of you is fully adjustable. You let me know when you're ready.
Ready.
Perfect. You may proceed.
Thank you, Judge. All right, Ms. Patel, while I get myself organized, will you please state your name and spell your last name?
Kamini Patel, Patel.
Ms. Patel, where do you work?
I work with the Hillsborough County Sheriff's Office in the crime scene section.
What's your current title and role with the crime scene section?
Forensic Services Manager for the crime scene section.
Back in 2010, were you in that same position?
No,
What was your position then?
crime scene investigator.
What is a crime scene investigator?
It's a person who's responsible for responding to crime scenes and documenting the crime scene via photography, videography, sketches, all dependent on the scene, and also locate, identify, preserve evidence for future analysis and processing.
Back in 2010, how long had you been a crime scene investigator?
With the Hillsborough County Sheriff's Office,
Between Hillsborough and then your prior experience as well.
approximately 7 years.
When you're working as a crime scene investigator, do you have training specific to preserving and processing evidence,
Yes,
as well as documenting items that may be either through photographs or documented in place?
yes.
Now, let's talk specifically about a scene. Not this scene, but just a scene in general. Are you one of the first ones there?
No.
Why?
I am after a support services employee, so we are not first responding officers.
When you arrive on scene, fair to say that patrol is there,
Yes,
and more than likely detectives are already there.
dependent upon the scene.
All right? Let's talk specifically about 604 Ocean Mist Drive. Did you respond to that scene on November 25th, 2010?
Yes, I did.
What time did you arrive?
Approximately 4:30 a.m.
How long, if you know, had units been on scene, patrol units, before your arrival?
Approximately 2 hours.
When you arrive, are detectives on scene?
Yes,
Are you briefed on what you're walking up to?
yes.
So don't tell me what anybody says, but how does this briefing go? What's the process?
I try to find out the first responding officers or the detectives on scene, and I ask them what they know up to that point, and as far as if they've done a walk through the scene or if we're allowed to walk into the scene to take an assessment of what we are going to be working with.
When you enter that scene, do you have to enter into the crime scene log?
Yes,
The time that you enter
yes,
and the time that you leave.
correct.
Is all of that documented?
Should be, yes.
All right, so now you've entered into a crime scene, specifically 604 Ocean Mist. Before you touch or move anything, what are you doing?
Usually do a walkthrough, and then we're usually taking photographs of the crime scene, overall photographs of the crime scene before moving anything.
What's a walkthrough?
A walkthrough is knowing the area that's in investigation and seeing what items of evidence or value have been located or identified so far by the first responding deputies or detectives and pointed out by witnesses.
When you're doing your walkthrough, you've got a detective with you?
Detective or a patrol
Are
deputy.
you discussing what you may think is important compared to what they may think is important?
Throughout the whole process, yes.
Now, you've done your walkthrough. Do you start taking photographs?
Yes.
What is the system that you're following in order to take your photographs?
Take overall photographs of the crime scene, mid-range photographs of any items of evidentiary value, as well as close-up photographs, and then we come back and also place photo markers to particular items of evidence, and then retake overall photographs, mid-range photographs, and close-up photographs.
Is that done prior to touching anything?
Yes.
Why?
To not disturb the evidence and show it and preserve it as much as possible as is when I arrived on scene.
All right, when you arrive on scene, you said about 4:30 in the morning?
Correct.
What's the lighting conditions outside of the home?
Dark.
Do you have any light not brought by the sheriff's office but exists there at the scene that you can see by?
Just on the property?
Was it closer to the house?
Yes.
Does the sheriff's office put down lighting?
Yes, we did for this scene.
How come?
To provide additional lighting to be able to locate and find additional pieces of evidence.
Are your photographs taken before or after the additional lighting's put down?
For this scene, they were taken after the placement of the additional light sources.
All right. Have you had an opportunity to previously go through your photographs?
Yes.
Take a look at them.
Yes.
And I'm showing defense, and I can put all the exhibit numbers in there.
Judge, we got a system here. If you approve, I'm going to kind of stand by.
Oh, yeah.
Here to see.
Absolutely.
I think we're good on everything.
Yeah, no problem.
All right, Ms. Patel, there's going to be a screen behind you, and I'm going to start with, is defense stipulating to them being moved into evidence? Let me do it this way.
I have no problem with the foundation, that she can lay the foundation.
Okay.
And so I don't think I have any other objection, but I'll just check with each one.
Okay, so just do them individually, and if they
individually.
have an objection, we can address it, and if not, I'll admit it at
They're
that time.
substantially the same.
I'm showing, well,
No problem.
does the court then allow me to publish these prior to them being admitted?
Well, no, just show them,
If
Mr.
If you're moving it, this one. no
Okay,
problem.
what's the number?
I'm moving State's Exhibit 1 into evidence.
It's admitted.
Okay, permission to publish.
You may publish.
And can I have a standing?
Yes.
All right, thank you. So permission to publish all of them.
Right.
once defense-
Just show him each one,
Thank
and
you.
if he has an objection, he can say, and if not, once you say the number, if there is no objection, I'll admit it. If there's an objection, we'll discuss it.
Thank you, Your Honor. All right, Ms. Patel, there's a screen over to your left. I'm showing you this first photograph, which is State's Exhibit 1. Do you recognize this?
Looks like an aerial photograph of the area around Ocean Mist Court.
There's a yardstick in front of you. If it's easier to use that and stand up, you can point to specific locations on this photograph that I'm going to be asking some questions about.
Yeah, you're welcome to step down if necessary. It's just that you won't have a microphone next to you, so you have to make sure you speak louder if you step down, and you're welcome to use that yardstick as a pointer.
Yes, sir.
Ms. Patel, where is Ocean Mist?
It's going to be right where the tree lines are.
And you're pointing specifically to 604 Ocean Mist.
Correct.
When we're looking at this photograph, is the circular road towards the top middle right all of Ocean Mist?
Yes.
Now, the specific scene that you respond to, you pointed to it. Go ahead and point to it again.
Right before the curve, the bend of the curve.
On the left-hand side of Ocean Mist, as we see in this photograph.
Correct.
I'm showing you, I'm showing defense, State's Exhibit 2.
No objection.
Admitted.
What are we looking at here?
Trying to place myself now.
Do you want me to show you State's Exhibit 1 to give you reference?
Okay, this is the bend of the circle, and so this is the property. Ocean Mist Drive is right there.
All right, so when we're looking at this white car, Is that white car associated with the home 604 Ocean Mist that you responded to?
I would assume. That's the location. I don't know if the white car is associated with.
Okay. All right. State's Exhibit 3.
No objection.
Admitted.
Another aerial photograph.
Yes, this is the close-up of 604 Ocean Mist Court.
Now let's look specifically at the kind of middle bottom of this photograph. It looks like there's a front porch there. Do you see what I'm referring to?
Yes, ma'am.
Is that where you responded for the majority of the scene that you're working on November 25th of 2010?
Yes.
Judge, these have already been moved into evidence.
Simply identify them then by their number.
All right, this is State's Exhibit 5A. I'm going to get this evidence tag out of the way. Is this that same front porch we just looked at in the aerial photograph?
Yes.
Now, let me, hang on 1 second. I want to draw your attention to this yellow thing down here by the fence. What are we looking at there?
That's an additional light source that we placed once arriving on scene.
Not something that was there before the sheriff's office arrived.
Correct.
When we're looking at the front of this home, where is the original lighting that would have existed prior to the sheriff's office arriving?
The front porch.
Only the front porch.
Yes.
The cars that we see in this photograph on the bottom right-hand side, are those law enforcement vehicles?
No.
Not sure where those are, but not law enforcement.
Correct.
All right. All right, this is already moved into evidence. It's 5B. Would you consider this a overall or a mid-range?
Still an overall for the perspective of items of evidentiary value, but mid-range for the whole overall property.
Now let's talk specifically about some items that we see sitting on the stairs, towards the second stair on the left and third stair on the right. What is that?
They're 2 styrofoam cups that are preserving 2 spent shell casings that patrol had located prior to my arrival.
Did patrol put down those cups?
Yes.
Is that fairly standard for someone who arrives before you to mark something that may be of interest to you?
Yes.
Do you exchange those styrofoam cups for evidence markers at a later point?
Yes.
Now let's talk about the balance of this photograph and the front porch. Do you have additional styrofoam cups on that front porch?
Yes.
Do you mark those yourself?
No.
Actually, that was a poorly asked question. Do you go back with evidence markers and mark those yourself?
Yes.
Okay. Were those previously marked for you by patrol?
Yes.
Now, when we're looking at the left side of this photograph and the left side of the front porch, was there furniture that was observed on that front porch?
Yes.
Was there a individual's body that was located on that front porch as well?
Yes.
And what side of that front porch was the individual located on?
On the west side of the front porch.
And then when we're looking at this photograph, left or right?
Right.
And was there something that was used to cover his body?
Yes.
What was that?
A white sheet.
When we're looking at this photograph, do we see that white sheet on that front porch?
Yes.
And where is it? Thank you. We're going to work our way through the front porch, but did you have exterior photographs around the entire house as well?
Yes.
Are those part of your overall photographs?
Yes.
And I'm showing 5C, already moved into evidence. Same front porch, right?
Yes.
Now, when we're looking at this front porch, from where you're standing taking this photograph, what is to our left?
To the left are 3 additional vehicles that were on the property.
Does that property go to a fence line?
Yes.
On all 3 sides?
Yes.
What is to our right when we're looking at this photograph?
There was a white Chevy van, a tree, and then a fence line to go towards the back of the property.
All right. Showing State's Exhibit 79.
No objection.
Be admitted.
Excuse me. This is the left side of that property.
Correct.
Do these white vehicles go up to the fence line?
Yes.
When you're taking your photographs, do you work your way systematically around the entire exterior of the home?
Yes.
State's Exhibit 78.
No objection.
Admitted.
Are you still able to see part of the front porch in this picture?
Just the east side of it. Yes.
Would that be on the right side of this photograph?
Yes.
Right along this right edge?
Correct.
The left side of this photograph, is that part of the, essentially the furthest out part of the property on that side?
Yes, the east side of the property.
State's Exhibit 77.
No objection.
Admitted.
Now give us some perspective on where you're standing taking this photograph.
I'm in the backyard and still taking a photograph of the east side of the property, so I'm facing the opposite direction of the previous photograph.
Now I'm going to show you the previous photograph, 78. We can see that blue car, correct?
Correct.
Now are you standing, maybe not on Ocean Mist, but closer to the actual road taking the photograph in 78?
Yes.
Now I'm going to show you, I think it was 77. Yep, 77. In this photograph, are you able to see the fence that goes along Ocean Mist on the front of the property?
Yes.
Show me where it is. Now, the blue car that we saw in State's Exhibit 78, is that the same blue car we're seeing in State's Exhibit, in State's Exhibit 78? Is that the same blue car we're seeing in State's Exhibit 77?
Yes.
No objection.
Admitted.
Showing you State's Exhibit 63. Where are you standing in relation to that front porch in this photograph?
I am to the right of the front porch on the west side of the property, so I'm in the northwest corner of the property.
The shiny fence we're seeing in the background, is that a metal fence?
Yes.
Is that the fence in the backyard?
Yes.
The fence that we're seeing down the right side of the photograph, the wooden fence, is that a side yard fence?
Yes.
And let me back up. Let me ask you about this. That yellow line we see across the photograph, what is that?
Crime scene barricade.
Is that put up by patrol prior to your arrival?
Yes.
What does that indicate to you?
There's possibly items of evidentiary value in the backyard that they were preserving.
64.
No objection.
Admitted.
Showing you State's Exhibit 64. Where are you standing on the Ocean Mist property now?
I'm on the west side of the home. I'm looking into the backyard facing south.
Same silver fence, metal fence that we saw in the last photograph, 63?
Correct.
No objection.
Admitted.
Showing you State's Exhibit 65. Is this the backyard?
Yes.
This one.
Yes.
Keep those on.
Yes.
I'm showing you 64, just for the perspective of the clothesline. Now we're looking at 65. Is that the same clothesline?
Yes.
Same backyard area, just kind of working our way around?
Yes.
What are we seeing in what I'll call the back middle of the photograph at the end of the home?
We are seeing along the fence line a blue chair that is leaned against the fence line.
Do you end up taking closer photographs of that?
Yes.
Mr. Grant, I'm going to need those back.
Okay.
Showing the fence, 76.
I've been reviewing these. That's so good.
So, well, give me the numbers that you're good on, and I'll admit them all at the same time.
Can I have 15 seconds?
Oh, sure. Yeah.
Look to them all. There may be one we need to talk about.
All right, so when we
That's
get
not-
to that one, we'll talk, but just You want to go through the, well,
I would suggest that the one we need to talk would be,
during the lunch break?
yes.
Okay. I just want to make sure the record's correct, though, by announcing what numbers and assuring there's no objection before I admit.
Okay. I'm showing Defense States Exhibit 76.
I admit it.
Yes.
Ms. Patel, is this that back patio or porch area that we saw in the last photograph, States Exhibit 65?
Yes.
Now let's start working our way down this fence line. States Exhibit 66.
Yes.
Admitted.
You mentioned a chair. Do we see that chair in this photograph?
Yes.
What did that chair indicate to you in terms, well, that's a poorly worded way of saying it. What's going on with that chair?
There's possible blood on the chair, and right above where the chair is, possible blood on the fencing.
67.
No objection.
Admitted.
I'm going to zoom in a little bit first on the chair. How close is this chair to that fence?
Leaning against the fence.
Do you see in this photograph where there was the substance that you believe was possible blood on the chair?
Yes.
Can you stand up and point to it for us, please? Now you're pointing to what I'll call the white rungs of the back of the chair. Did you notice the substance there?
Yes.
Did you also notice the substance on the fence itself above the chair?
Yes.
Was that same substance that you said was possible blood?
Yes.
Did you have other crime scene technicians working with you that day documenting specifically the back of the property with their photographs?
Of 604 Ocean Mist?
Yes.
No.
Would it have been Mr. Cashwell, Ronald Cashwell?
He did the opposite property, I think Domino Drive.
Did he also document part of that fence with it as well?
Yes.
Okay. And I'm showing you a photograph that's already been moved into evidence, 68A. Is that still, let me back out some. Is that still that same fence line that you were documenting, but from the inside portion of the property?
Yes.
And then I'll show you 68. Do you recognize that fence?
The same fence.
Your photographs are on this side or the opposite side of that fence?
Opposite side.
Thank you. States Exhibit 59.
No objection.
Admitted.
Showing you States Exhibit 59. Now we've moved to which side of the property in this photograph?
We're back to the front yard. We're on the west side of the property.
If we're standing on Ocean Mist, looking at the photograph, is this to the right side of the front porch?
Yes.
States Exhibit 60.
No problem.
Admitted.
Showing you 60. Still the right side, working our way kind of around the right side of the home?
Correct.
States Exhibit 61.
No objection.
Admitted.
Further down that right side of the fence.
Correct.
62.
Yeah. Based on subsequent conversation, no objection to that.
All right. Admitted.
This is States Exhibit 62. Now, Ms. Patel, I want to draw your attention to specifically that yellow marker number 17. What is that marker?
It's a photo marker next to a wallet that was
So
located.
before we get into what it's marking, what is that actual number 17 yellow thing?
It's a marker number to identify a particular piece of evidence.
Now, when we're looking at evidence marker 17, what's it marking?
The entire wallet.
Do you take a close-up photograph of evidence marker 17.
Yes.
Showing defense 62A.
No problem.
It's admitted.
Let me back out a little bit. Is this that close-up of 17? Evidence
Yes.
marker 17.
Yes.
When you're taking this photograph and you're marking that item, is that exactly where you found it?
Yes.
Exactly how it's laying?
Yes.
Have you touched, disturbed, or moved that at all?
No.
Showing defense states exhibit 5.
I thought it was already in. If it's not, no objection.
It's to be admitted.
States exhibit 5, we're back to the front of the house, correct?
Yes.
Okay. States exhibit 6.
No objection.
Admitted.
Ms. Patel, would you consider this a mid-range photograph of the front steps of the porch leading up to 604 Ocean Mist?
Yes.
Same styrofoam cups are still in place, correct?
Correct.
Have you moved, touched those, or what's underneath them at this point?
No.
Marking and photographing everything as it sits?
Yes.
States exhibit 6A is a photograph that we need to approach on.
Okay. So is it a good breaking point?
I think so.
All right. Perfect. Ladies and gentlemen, we're going to go ahead and take our lunch break. I will advise you again not to discuss the case amongst yourselves or anyone else. Also, not to do any research related to the case and avoid all reports of the case outside of the courtroom. We're going to go ahead and break till 1:15. So that gives you a little more than an hour and 15 minutes to enjoy your lunch. We will see you back after lunch. All rise for the jury. Jury has exited. Everyone may be seated. You get to step down and have lunch as well. Just because you're on the stand, don't discuss your testimony with anyone. You're welcome. How about if we come back at 1:05? 10 minutes enough to talk about those?
I think so.
The objection I
Yeah.
have is very brief.
Well, let's do it now.
Okay. Well, I can show you it's.
What's the number? 6.
I was going to
6A.
6A.
Hold on, you're going to have, I'm assuming you're going to have an objection to 58A as well. We can address all of it at the same time.
Yes. 58A and 6A. Oh, sorry.
No, yeah, it was my fault.
They have pictures. These pictures show Mr. Gutron, the deceased, on the porch. Our argument is it is not relevant. It does not tend to prove or disprove a material fact. Obviously, Mr. Gutron's death is not in question, and that he's there exposed.
Is it a 403 argument?
It's a 401 argument.
Not relevant.
Right. It's not relevant. I will say, I think case law has said 401, 402, and 403 work together. So I say there's nothing to prove or disprove a material fact. 402, of course, says all relevant evidence is admissible. Then we get to the 403. So if the court is persuaded that there is any relevance as far as proving or disproving a material fact, then we can get
I mean, it is the crime scene, but what specifically is the material fact that the state asserts that these photographs either prove or disprove?
Judge, I'll need to look at each one. I grabbed the whole stack because there are going to be others that I anticipate defense would object to.
Well, I do apologize. I said I could do it, but I thought it was going to be hard. I've got a meeting that my JA has signed me on to that I need to get to. How about if we come back at 1? Even if the jury has to wait for us a little bit. And I haven't forgotten that we will discuss calling Mr. I'm happy to do that.
Right. We'll
Talk about I want to bring up something with some of the other. Christina, can you come up here and try to find my chart, my jury chart?
Yes, sir. And, Your Honor, before we get too far into that, can we approach quickly?
Yeah, absolutely.
Here you go.
You found it? Oh, you have a backup.
I always keep a backup.
All right.
For you.
Do you need white noise? I have a question just for the court TV, the media. Apparently, there's another live stream that's going, and the juror's name that we mentioned earlier was broadcast on that, and people who were, I guess, commenting and using the juror's name. So I don't know who cuts that if when a juror's name comes up, and what is that up to someone else?
It is up to the media outlet to take responsibility for that. We inform everyone when a juror's name has gone out, but we can't.
So you're not cutting it from here so that it doesn't go to the feed. It goes to the feed that other outlets are using, and then it would be incumbent upon each of those outlets to actually, I guess, delete it or somehow. There's a delay, correct?
I can't speak to everyone's delay process. I can only speak to
Right.
We have a delayed process, so it tries to catch those things. But when the court permits a live stream, it's incumbent on the individual media outlets to follow the court's orders. So there's always a chance.
Right, and it wasn't court TV. I'll say that it was another. So what I'm going to do is, based on what I've heard, is be a lot more careful not to mention a juror's name, but to use the number since we have these charts. So from this point forward, we'll use the number of the jurors, and we'll also be cognizant of this and revisit it in the end. If we need to mention jurors' names, we'll use numbers and maybe initials. Sometimes we do that. But for purposes of our discussions in here right now, including the juror we've already talked about, I'll just use numbers. And that was number 3 that we talked about this morning. Is that the same? Everybody on the same page on that? Yes. Number 3? Defense have their chart? Yes. All right, and it was number 3. I have something additional related to number 3. Now, we had discussed earlier the possibility of bringing in number 3 and discussing with number 3 the situation from this morning. Number 3 had indicated to the bailiffs yesterday that he believes that the photo lineup shown on the monitor, that one of the people may be in the audience. Now, that was yesterday. I'm going to say I find that highly unlikely that one of the people who happened to be in the photo lineup, which is I don't know. I don't know. But that is the same juror who we may be talking to about whether or not he wasn't paying full attention this morning. So I could inquire about that, and then we could discuss what our response is based on whatever he has to say about that. The other issue is number 11 indicated that she may know Dr. Halprin. So, I mean, I know, and we try, and in jury selection we read the names, but I'm thinking out loud here. My suspicion is that we would need to talk to her, but it's not a definite. It's a may know Dr. Halprin.
The problem if you do that is, of course, we ask questions that we don't know the answers, right? And
Never ask a question you don't know the answer to.
that's right, or where it can hurt you. And in this case,
Well, I think in this case, though, we can.
right. So if she says, "Yeah, I think I know him," I can still be fair and impartial. I guess the question is going to be where we go from there. What potential information? I'm just wondering if we just by even asking the question, can she continue?
Well, yeah.
Yeah, I mean, it's not any different than we would have asked it during jury selection.
Right.
I mean, it depends. We don't know the answers. If she says that she can't be fair and impartial, that's why we have alternates.
I got you.
So, should we bring in number 3? We hadn't really decided. I think both sides were kind of talking out, considering options, whether we bring in number 3 to ask him, and I won't require you all to. I'm not going to put that on you all. I will say it came to my attention that you might have been sleeping this morning, and we just wanted to talk to you about that.
We're using seat number, but the juror number is the one in bracket.
You're right. It is juror number 71, seat number 3. I apologize.
Sorry,
I should say both of those.
Right, I lost you for a second because I thought we were still on 11.
Well, I was referring to the chart that
Yes.
we handed out, but it actually has both numbers. Juror number 71, seat number 3.
Sure.
Before I bring them in, though, I want to know if there's any specific questions either side wants me to ask him.
Judge, I did start to look in the afternoon, and he seemed to be alert and paying attention. I don't have any objection if you want to inquire about this morning, given the defense attorney had raised some questions about that with regards to what he alerted the bailiff about the photo pack. I don't necessarily think we need to put questions to him regarding that. I don't know if the defense wants to propose that he be instructed not to concern himself with that, or I'm not sure if they have any. I'd like to hear what they have.
Yeah, no, see if they have any questions. I agree with what you said about the sleeping. I watched him after, and
okay.
After I made them stand up, I didn't see any issues with him. But when it was brought up and we were at the bench and we looked over him, he appeared to be. But, he may tell us that he listens better with his eyes closed. I don't know what he's going to say about it.
Judge, I'm concerned about picking out that juror and asking him, "Hey, were you sleeping?" To be honest with you.
Okay.
Because I think, if he believes that either the prosecution or the defense alerted the court, he is going to feel bad one way or the other.
I hear you.
So I think that if we just tell the entire panel again that it is very important that they are attentive throughout all the testimony, that if anybody is tired and feels like they're dozing off or anything, please let us know. We'll take a break. I
agree. I think he got the message when I made them stand up. I think he probably realized, because he has been, every time I've looked since then, extremely attentive.
With reference to the second issue, we all know that no one from that particular photo pack was in here.
Possible, but highly unlikely.
Yeah, I don't believe so, but I think that maybe bringing him in and letting him know that that's not the case. I mean, I don't want him to be left thinking that someone in the photo pack was in the room, but by the same token, I don't think we should make a big deal of it.
Yeah, I mean, I don't have a problem with that. I will skip talking to him about sleeping, bring him in, say you had raised an issue regarding one of the people in the photograph potentially being in the courtroom, and I have no problem assuring him that that was not the case, asking him if he has any questions related to that, and seeing if he does. Is that sufficient for the state?
Yes, Judge.
The defense?
Yes, fine.
All right, so let's bring in...
What about Halpern? Are we going to do anything with that?
Well, all right, we'll go ahead and discuss that before we... All right, and that's the other. That is seat 11, number 28, is the Halpern, may know Halpern.
Judge, I would want to inquire, obviously, that is, obviously she was concerned enough to bring it to our attention. So I do think that, and I don't have any, problem with you handling that and just inquiring her if she.
Well, I'll say, why is it that you think you know? How do you know, if it is? And then ask the questions that I would have asked if they had raised their hand in selection as to whether that would affect their ability in any way to be fair and impartial, whether they could judge that witness if the doctor testifies, credibility as they judge any other witness. So similar to the instruction on law enforcement witnesses and expert witnesses. Is that acceptable to the defense, those questions?
It is, Your Honor.
All right.
Your Honor, it looks like from my quick search that there is a Dr. Joshua Halpern in Tampa and a Dr. David Halpern.
Oh,
so maybe
wow.
that may help.
Thank you.
Clarifying?
And which is ours?
David.
But there's also a Joshua. Well, in asking them how they think they know, I'll get additional information, and we may be able to determine and assure them that that's not the doctor. But I will want to ask them specifically if, in fact, it is the doctor that they believe they know, whether that would in any way affect their ability to judge the credibility of that witness. All right. So let's bring in number 71. Oh.
Yeah, that's going to a couple of minutes.
I'm sorry?
It'll be a couple of minutes.
Okay. All right. Not a problem. Oh, they're all going back. Weren't even back there. So that's perfect. While they're doing that, let's move on to the photographs. I remember 2 photographs that I was shown that included the crime scene and one of the bodies in the crime scene.
I don't know if defense has objections to others. I can make if the court wants to see the photos or which ones.
I'll need to, before I make a ruling, I'll need to see. Do you recall the 2 that I had in my hand that you?
58A, sorry to interrupt, and 6A or B.
That sounds correct. And can you look through that and see if you have objections to any other ones so we can address them all at the same time?
So those are the 2.
Approach while she's pulling.
Yeah, no,
I
not a
don't want
problem.
to. I'm trying not to pull the other ones because they're not in chronological order.
Sure.
So if we can keep them in this order, it's going to make the witness testimony go a lot smoother.
This is 6 alpha, 58 alpha, sorry.
All right, so
So
you want
take a look
to
at
do
these.
argument on these at this time? Or
I
do you
think
wanna-
we can probably argue all of them at the same
Okay.
time.
So.
Would it be easier for us just to walk up there with the photos so we can keep them in order?
Sure.
This is, looks like 18.
Number 18.
It's got a hand.
The argument is going to be the same basis for all of them, right? Correct. So let me see. Yeah.
Can I keep them back in order?
Yeah.
The court want to hang on to them?
No, I can remember. And I've got these 2.
I'll put those back in after the first one. There's this one.
What number? Well, what number?
C.
50.
56, Charlie.
C.
Okay.
56B, Bravo.
Okay.
Is this one you're objecting to?
Oh, yes.
56.
Just 56?
Just 56. 56 alpha. Because I'm going through and tell me if there's any you're
Right.
objecting to.
Yes.
44.
44.
Yes.
25.
25. What number?
9.
9?
Yes.
11.
11?
Yes.
28.
Let me see that one.
I think I see that one.
And 29. That's the last one.
And I can give you back now, and I have on my list 6A and 58A.
I'll give the order of one of them.
All right, so let me hear.
Instead of here and right
No,
back.
no, you don't have to. Let me hear the defense argument related to the objection.
So 401, as I said earlier, obviously requires evidence to be relevant, and relevancy is defined as that which proves or disproves a material fact. 402 tells us that all relevant evidence is admissible, which takes us to 403, which outside of characteristic evidence is the last part of a court's analysis. And I would argue any time we make a relevance objection to the court, we're actually asking the court to consider 401, 402, 403. In this analysis,
But you would agree that it gets derailed if I find it's not relevant. There's no reason. It gets out on 401. Then it's not relevant.
You took the word.
I have to find it's relevant to get to, then 402 says it comes in unless 403 says it doesn't come in because the danger of unfair prejudice.
You took the words right out of my mouth. It starts. That's why my argument is 401, right? That these pictures do not tend to prove or disprove a material fact. I know there's a couple of them that my argument, I don't want to say may not be as strong, but I don't know how to couch. For example, the last one you saw, I think, was number 29, and I see that has a picture of what looks like a broken glass pane.
Yeah, a hole in the glass.
Right, and
It's very blurred as to any body that's in that one.
right, the body is blurred, and so that I can just, by doing this for a little bit more than a minute, can understand what relevance that may have, right? So I get where they're going. But some of them, I think I showed one to you, I can't remember which one that is, that has the body with the sheet on it, and it has, I think, the right arm or left arm, whatever arm it was, partially exposed.
That's 56B.
I think that is 56B. The photos of the uncovered body, if they're not the primary focus of the picture, I think they should be taken out, or you can blur those out or obscure that in some way. I understand that they may want to argue about shell casings that were found underneath the porch when the porch was dug up. I may be saying that inartfully, but in any event, I got that. But that body is still there, and that could lead to a confusion of the issue. And I don't think that's what the prosecutor even wants them necessarily to focus on in some of these photos if they do have some other evidence. And of course, you also saw photos of the decedent on the porch. We've stipulated that this poor fella did pass away, and there's identification of the victim is not an issue. So to varying degrees in these pictures, we're starting with a 401 analysis, and in any of those photos that you get past 401 in your analysis, or we're certainly saying 403, where the dangerous and unfair prejudice substantially outweighs any probative value. It can confuse the jury or mislead on issues. That should be.
All right. Tell me generally from the state what the relevance is of these, and I may have some specific questions regarding some, so I'll ask you to pull them out and take a look at them. But generally, what's the relevance of these in light of the definition of 401 that they tend to prove or disprove a material fact?
Judge, this case is based on nuances. So we're looking at cartridge casings, we're looking at projectiles, we're looking at the location of where they were found, of what material they would have passed through. So decking, siding on walls, windows, those types of things. The position of items on the porch that become relevant to showing where victims were, that corroborates their testimony. It corroborates other items of evidence. It's going to show the position, arguably, of a shooter. Not specifically, but we're shooting into a dwelling. We're shooting with projectiles going down through a porch. We're showing the position of the victims to show that they're face down, that when the body is moved, because in one of the photographs, Mr. Guitron is covered by a sheet with you can see it's a right hand with a right thumb facing downward, showing his position when the sheet was placed over the body.
I think that's 56B.
I can check for the court, but that body position is going to be when law enforcement has placed a sheet over it. Dr. Mainland's going to testify, she goes to the scene, that the body's moved. They're looking for potential projectiles through the decking. They're looking for entry and exit wounds on the body. This is going to help these witnesses explain their testimony, explain where they are and what they're looking for, why they're conducting the investigation that they are. When defense is arguing that law enforcement's not doing a thorough investigation, this goes to show the steps they are taking to ensure they're capturing all evidence, that they're documenting it in place, that they're ensuring that they are getting potentially trajectory and path of travel. On some of these photographs, we've got blood smears that are going to be substantiated and corroborated by witnesses saying, or by victims saying, they jumped over the railing to exit. Those blood smears on that railing will show that is in fact the place where the witness is saying, or the victim is saying, I jumped over the railing. We're going to have projectiles that are recovered in the home, showing windows that are broken to support that those projectiles would have gone through those windows at that point, that it's in that path of travel. The decking is removed and the siding is taken off of the patio, or off the porch, to show that there's projectiles and there's cartridge casings recovered underneath there. Mr. Guitron's body is in those photographs, but the purpose of introducing those is not to overwhelm the jury with graphic images, but to show this is where his body is located. We've removed the siding and the decking directly underneath it, and we have cartridge casings and projectiles located there. So his body position matters very much when we're making those items of evidence relevant.
What about 56C? It's the close-up of his face.
Oh, so there's a series of photographs of his left hand, his right wrist, and his neck.
So that includes 56A, which is the one with the watch in the ring.
Correct, and that's to show that this was not a robbery. That those items of evidence, they're left behind. If this was a robbery and we're coming in and we're killing somebody because we're taking valuable items, these photographs show those items were left behind.
Well, I don't see that in 56C. The one is just the head.
He has a necklace on. You see a gold necklace on.
Let me see 56C
Yes, sir.
again.
Do you want me to bring up the other ones and show you those as well?
No, I took some notes when I saw them, so I remember the images in my head with these notes.
It's because he has a necklace on.
And your position is the relevance is to support a theory that this was not a robbery because there's clearly a visible necklace that was not taken.
Yes, sir.
And that's the same regarding 56A, which has the gold watch and the ring.
Yes, ma'am. Yes, sir. My bad.
What?
I said yes, ma'am.
That's
Sorry.
all right. I've been called worse.
All right.
I've been called George.
That's true. You have.
Not that that's a bad name.
Just not your name. Yes. So the reason that we're introducing those photographs is because it's going to show that these items are visible. If this was a robbery, that doesn't comport.
All right.
briefly respond?
Yes, absolutely.
As far as a robbery, we have not put that theory into evidence. If we have in our opening statement, or if we do in subsequent cross-examination say that this was actually a robbery, that argument may hold a little bit more water. Furthermore,
It hasn't been argued at this point in time, but just because someone's jewelry is not taken from them does not necessarily preclude that this was a robbery. As the court knows, sometimes we have attempted robberies that take place. So that has not been put in issue yet, that the person who actually did this crime was committing a robbery. In fact, we've got a variety of ideas why the person, whoever he is who did this, did do this, right? And so as far as the robbery, I ask the court to reject that unless or until at some point in time we open that door or we make that suggestion. And as far as the rest, I understand that there's going to be an element of that we will have cross-examination. Ms. Olive has already made the argument, made cross-examination questions. I will make some of Ms. Patel, that just because a shell casing is found in a certain area does not necessarily mean that's where it was when the event occurred. We've already heard testimony that at some point in time this was understandably chaotic. There were people in the house who were coming out to help these men. One of them actually ended up inside the house in the shooting, and it's very quick aftermath. Fire rescue came, police came, and so I understand that that's an argument that they want to make, but they can make that without showing unnecessary pictures of Mr. Trump.
All right. I've looked at them, each of them. I've made some notes that I have here, and they all appear to be photographs of the crime scene in this case. It is a homicide case, and they are all photographs of that crime scene. So I do find that they are relevant under 401 based on the fact that they're photographs of the crime scene. I find under 402 that makes them admissible, but then I have to go to a 403 analysis. And while I do find them to be potentially prejudicial, I do not find that the prejudicial effect substantially outweighs any probative value. So I'm going to overrule the objection.
Understood.
Can I make certain?
Certainly.
We have made our record.
Yes.
I am not going to object in front of the jury.
Oh, yeah.
You've made your ruling.
Right.
Got it.
Right. So they're not going to, let's see. The way that we've been doing it, they ask, and I certainly understand why you wouldn't want to say, no objection. But what I'm wondering is,
Can I make a suggestion?
yes,
I know I'm
it may be the exact same thing, but I'll let you. Maybe better than mine.
I went bam. What I was going to suggest is that she formally introduces them now, and they will be received in evidence. If she feels like she wants to say, or if the court wants to feel like we've...
It is better than mine. I was going to say that she just moves all those that we talked about when they come in, and I say admitted, but that's not I don't think that's necessary unless you want it. I'll say they're admitted now outside the presence of the jury, which means you're able to use them and show them. And they go into the stack that goes back.
Then I'll just put the exhibit numbers on the record as
Now.
I'm showing them, so that the record is perfected for what exhibit we're talking
Right.
about. But if the court wants, I can put all of the exhibit numbers on now. Defense can make their objections. The record will be clear.
Well, and you know what? The ones that they don't have objection to can be admitted now also. So that it doesn't call those out when they're asking on some of them, but not asking on those.
You got it, George. Judge.
Do you want me to go through the exhibit numbers
yes.
now?
Go through all of them. I have a list, and you can check me if I'm wrong. When they get to one of the ones that you objected to, I'll say that the defense objection is preserved.
I don't want that said. I want it...
No, now. Right now. Because at the end, you're going to agree, not agree, but you still maintain your objection to those that you posed an objection to. But as she mentioned those, I'll say there was an objection posed, so the record is clear.
Yes, sir.
Exhibit 29. and that's one that's objected to.
Well, you know what? Let me make my list better. I have 6. Yes, I do have 29, but I've got them written all over. So let me put them in order: 6, 11, 9. 25, 29, 44, 58, 56A, 56, 56B, 56C, and 28. Any reason, Mr. Grant, to disagree? Because we just do it this way. I'll say that the defense has objection to those.
Made my objection. I make it again. I understand your rulings, and so you consider that preserved.
Right.
I'd also take it one more level, of course, because I'm a defense attorney, to make sure I...
You used to be a prosecutor. You remember
Once
that?
upon a time, I did do that. Yes, sir. I did a lot of things. But what I will say is, in the event, that tracks with the numbers as I was watching. In the event that you missed one, we went through
Absolutely.
and refer backwards so that I don't miss.
Absolutely. We called them out as, so yeah, if there's anything, we can go back to that, but you're not waiving any objections by agreeing to this group.
The record should be clear that
in case I missed something.
Any picture of any part in whole or part of Mr. Catron's body that's not covered, we're objecting.
You object to.
And we feel like we've covered all those numbers.
Okay. So right now, you're moving all of them in, including those they object to.
I am. States Exhibit 29, 28, 27, 26, 55, 54, 53, 52, 51, 50A, 50, 49, 48, 47B, 47A, 47, 46, 45, 13, 15, 14, 12, 11, 10, 9, 38A, 38, 37, 40A, 40, 39, 35A, 35, 32, 34, 30, 31, 33, 43, 25, 36, 44, 24, 23, 22, 56A, 56, 56B, 56C, 17A, 17, 16, 19A, 19, 21, 20, 18, 58B, 58A, 8, 7, 6A.
All right, they will all be admitted at this time with the caveat that those that were specifically discussed, including all those that show any portions of a victim's body, are over the objection of the defense.
Yes, sir.
All right. So we need to talk to those two. Whitman, I apologize. Number 3 regarding Halprin. So let's bring in No, I apologize. That's number 11 regarding Halpern. Let's do that one first. Number 11. It's seat 11, number 28. And the other one was Joshua Halpern. Was that correct? Halpern.
Yeah, we may want to confirm when we talk with her.
Halpern.
What her last name is, because I know a Halpern, I know a Halperin, so.
Yeah, I was mispronouncing it.
I can check if there's a Halpern too. This is
Go ahead. Doesn't hurt.
You know, maybe in the opening when I referenced his job title, that may have sparked a memory, if it is the same one.
For number seat 11, yes.
all right. You're entering.
Hello and welcome. Please don't be nervous. Go ahead, have a seat, make yourself comfortable, and everyone else may be seated. We brought you in because you had indicated to one of the bailiffs, I believe, that you may know Dr. Halpern. Is that correct?
Yes.
How is it that you think you know Dr. Halpern?
I went to him for a procedure.
Okay.
Actually, 2 procedures, I believe.
Okay, now apparently there's 2 Dr. Halperns in the Tampa Bay area. One is Joshua and one is David. Do you happen to know the first name of the Dr. Halpern that you went to?
I believe it was David. And he has an office just off of Kennedy, just a block off on whatever that one-way street is.
Can you tell us, I don't want you to disclose any personal information, but just the general nature of the procedure?
He was a plastic surgeon because he took a cancer thing off.
Okay. Now, assuming that it is the exact same doctor that you went to for that procedure, and he walks into this courtroom at some time in the future, I need to know whether that prior relationship that you had with him is going to affect your ability to judge the credibility of him as a witness in any way.
No. I mean, I just saw him a couple of times. He did do the procedure. And the one procedure I did look at my papers to make sure, it was like in 2009.
Okay.
It was a while ago. And the
All
other
right.
one was after that, but it's still been a while ago.
A long time.
Yes.
So can you assure me that you would be able to judge the credibility of him as a witness the same as you would judge any other witness in this case?
Yes.
All right.
Yes.
Thank you very much.
Okay. I just want to make you aware.
No,
I didn't want to
absolutely.
make
This is the way it should be, and I apologize for bringing you in like this, but we just have to verify that to make sure.
Okay.
All right.
You done with me now?
Absolutely, yes. All rise for seat number 11. Okay, before we bring in the other one who was in seat number 3, we agreed that it was just going to be to tell him that the person in the lineup was not in the courtroom. Is that correct? We're not talking about sleeping.
That's correct.
All right, so we'll get seat number 3. Previously number 71. Is this number 3?
Yes, sir.
All right, let's bring him in.
All right. You're entering.
Go ahead, I apologize. Go have a seat, any seat, to make yourself comfortable, and then I'll let everyone else be seated. You are technically in seat number 3, previously juror number 71, and you had indicated to the bailiff, sir, first of all, I apologize for bringing you in under these circumstances, but you gave some information to the bailiffs that we wanted to further address with you, and that is that you believed that the photo lineup shown on the monitor, that one of them may be in the audience. Is that correct?
Yes, that is correct. Only during opening statements yesterday morning, briefly, it was a well-dressed gentleman again, whose head recognized one of those. This gentleman could have been a counsel, a lawyer for personnel, but he was in this room.
So I want to assure you that there was no one in this courtroom that was in that photo lineup.
I wouldn't imagine there was.
Okay.
Such a striking resemblance. And with the protocol you're taking, I
Understood. And we appreciate this because then I have to ask you the next important question. Even after I've assured you that no one from that photo lineup was in the courtroom, does that in any way affect your ability to remain a fair and impartial juror in this case? All right. So you accept my telling you that no one from that photograph lineup was in this courtroom. Is that correct?
I do accept that. You have cameras, I'm sure, plenty of other people watching these things.
Absolutely. So again, thank you then, Barry. Did you have any other questions related to that?
No. So thank you for this
All
opportunity.
right. Not a problem. We thank you for bringing things like that to the bail's attention so that we can address it. All rise for juror number 3. I think we've taken care of everything. We'll keep watching him for the other issue, and if any need comes up to readdress him or we see something, we'll address it at that time.
I thought you were going to address the panel as a whole about...
I'll remind the panel as a whole about the need to, that if they are tired, to let us know or anything like that. Yeah, I'll include some in my welcoming them back and apologizing for the delay and accepting full responsibility. I'll weave it into that.
But you can even tell them we saved them time with discussing pictures, right?
Well, I'm not going to go into
I
that.
understand.
Yes, I do want you to line. There wasn't. Wait.
We need a witness.
What?
We need the witness.
Oh yeah, let's bring the witness back in. But was there anything else we need to discuss before we get to jurors?
Judge, I was satisfied with your questioning. With regards to juror number 11, I may do some additional research and ask for some argument later. I don't want to delay the trial anymore. I understand what her answers were. I do have some concern, however, that is a critical defense witness, and the fact that she's been personally treated by him. I know that she said she could be fair and impartial, but just I don't want to waive anything. I may do some research later tonight. I would give it to the defense, and we could make argument at a later time.
We'll cross that bridge when and if we come to it.
Thank you, Judge.
All right. I won't consider this a waiver of your opportunity if you choose to do so.
Okay. Thank you, Judge.
Anything from the defense before we get them?
No, sir.
Let's line them up. Let's bring them in.
Judge, want to get the witness first?
Oh, yes. Well, it's going to take them a minute, so let's get the witness, yes. I just assume all those things will automatically come together. While she's lining them up, we should be able to get the witness on the stand. Back. Did you have a nice lunch? All right, we're going to put you on the stand. We're lining the jury up, and as soon as they are lined up, we'll bring them in and we will proceed with the direct examination. You can sit if you like. It takes a moment to get them all. They will let us know to stand when they come. I just like to stand as much as I can because I know I'll be sitting for a while.